What are we starting with today? Update on the
USCIS policy
USCIS
challenge, right? So on December 2nd and January 1st, USCIS rolled out memos where they put a hold on all immigration benefits for people born in or citizens of 39 countries plus the Palestinian Authority. We're not the only ones that are filing lawsuits about this, but I am tracking them better than anybody else, I think. So there are 7 lawsuits that have been filed so far. We are onboarding 3 more right now, so this should go to 10 soon. And I understand there's a class action that'll be filed within a couple weeks. So it'll go to 11, at which time it won't, all the numbers will be too small to read on the screen, and you'll have to trust me to tell you what they say. So of the 7 lawsuits that have been filed, we have filed 5 of them, one in Northern District of California, one in Maryland, another one in Northern District of California, one in DC, and one in Colorado. The 2 in Northern District of California have the same judge. I had a hearing before that judge yesterday in the first case. The hearing went very well. I'm hopeful for a decision maybe within a week. We had to get the judge both I and the government attorney had to get the judge some additional information. But it was a good hearing. The government attorney, me, and the judge, we all really cooperated in helping her understand the issues. And actually, she probably understood the issues better than I did. So, I mean, like, we're fortunate to have a very smart judge. What else do I say about this? The next hearing is in 2 days. That's 2/13 in Doe versus Trump. That's before Judge Julia Kobik in the Massachusetts. That's Jim Hacking's case. I've been communicating with email with both Mr. Cook and Mr. Hacking about their cases and our case and see how we can help each other. I know that they also got the administrative record in that case too. So far, what's been produced as far as the administrative record is the December 2nd record. We're waiting for the memo for the record for the January 1st memo, but in the Baden lawsuit, number 5, see, I've got their step to produce AR that was filed today, where the government has agreed with me in order for us to drop that motion, they're going to produce that record by the 20th.
And that's the motion for expedited discovery that's being dropped, right?
It's the green section.
Okay.
The purpose of a motion for expedited discovery is to get at the administrative record so the judge can see what the government considered or did not consider when they made the policy. And basically what the administrative record said for the December 2nd policy is the only thing that they considered was this is going to cause some applicants delays and it's worth it for national security. That was it. It was one sentence. 55 pages, but only one sentence was deliberations. Usually, administrative record is thousands of pages and a lot more deliberations. Some things they didn't consider, the reliance interest of people that made USCIS applications relying on the expectation that they would pay this fee and they would get a benefit decision. And a consideration that I think is interesting is the consideration that the policy itself undermines the goal. If national security is really the objective, many people applying for adjustment of status have bad cases that will be denied. And normally they would have been, put in removal proceedings. Not now. Now they're frozen. They're like safe as can be because there's a policy preventing USCIS from giving them decisions. So, they didn't really think out this policy, obviously.
Also, lots of them already received the AW or even a I-140 approval. That's something of national importance.
Yeah. They didn't consider that a lot of these folks are in national interest. They didn't consider that a lot of these folks are doctors trying to work at hospitals and cure the ill and find the cure for cancer. They didn't consider things like that. So I'm very optimistic about our litigation and the litigation of our partners. I am eager to see this form fill out a little bit more. Let me see here. To be filed on 2/12. The Colorado motion for preliminary injunction. Chuck, is that you or? Yeah, are you working on?
Yeah, I'll call you sometime later today to get it filed.
Okay, that's coming together. Okay, but you didn't know there'd be accountability today. And Kathleen, you're working on one of these cases too. Which one are you working on?
This is becoming a weekly meeting now.
Yeah.
Yes, I am helping with the naturalization lawsuit, the N400 group lawsuit. The team effort will come through in the DV 2026 lawsuit, but I've also I'll also be helping with that. But
so you're working on the next N400 group.
Correct.
Okay, cool. And I know that Garrett, who's not here right now, is working on the reply in our Maryland case because that's due on the government. It says due 2/10. They filed their opposition in Sag-Haffey yesterday, and our reply is due actually not 2/17. It's actually 14 days in Maryland, so it's due 17 plus 7. I never could do that. 24, 2/24. Yeah, February 24th. So he'll probably get it filed before then, though. I'm hoping that the Maryland judge gives us a hearing. But, judges can issue orders without hearing, too. So that's a lot of information. Based on all that, Rabia, do you have you tend to be the collector of questions.
For the USCIS, no, we do have a lot of 39 country pause questions, which is adjacent because the 39 country travel ban, not pause, travel ban. The 39 country travel ban was the underlying reason for the USCIS pause. So.
Right. And we are not currently offering litigation challenging. If you're outside the U.S. and trying to do a consular process and you're subject to that proclamation, we don't have a lawsuit for that.
We do have multiple pending in court, though, right? Do you want to provide an update?
Yeah, I don't have a spreadsheet for that, but we do have about 5 or 6 pending in court with a very important court date coming up on the 19th that you will be able to listen to live. That's at our Fine versus Trump arguments, oral arguments before the Circuit Court for the District of Columbia. Our associate Garrett May will be making oral arguments. He's doing a moot, I think, today or tomorrow or something, practicing, so he'll be ready to go. But the issues that will be in that case affect a lot of people. One of the issues is whether or not Proclamation 10949 is lawful. One of the issues is whether Section INA 212F that the government loves to use as a visa issuance grounds, visa refusal grounds, whether that's lawful, because technically it's an entry refusal grounds. Like it's a reason that they can prevent you from entering, but not a reason that they can prevent you from being issued a visa. And in the past, we've been able to get judges to order visas issued subject to proclamation. So that's why that's an important issue. I've talked a lot.
Thank you.
I think I have a piece of news to share that the 75 country ban that does not include China. Yeah, not our lawsuit, but the State Departments. And yesterday, the embassy or consulate of a U.S. consulate or embassy in China posted a notice that China is included, and that caused a panic. But China is not in the 75, so they clear that out.
Right, I sent you this somewhere. I think I can't remember. Teams or Twitter or something. I saw that. That was pretty crazy. there are so many different bans, pauses, and holds that even the government employees have trouble keeping track, right?
Yeah.
I can't
you
imagine
also-
the new hires that have started this week.
Oh, yeah.
Just
Did you all see Senator Kennedy this morning before the House?
Yeah. He didn't know anything.
No, he didn't know who Edlo was, and I shouldn't say that. That's mean.
It's pretty bad.
Okay. Okay, so let me give some update on our onboarding for the DV group lawsuit. The
Okay,
onboarding.
let's do that first.
Is that okay?
Yeah,
DV?
let's do DV, and then we do 75 country, and then we do questions.
Okay. Yeah, so onboarding for the DV group lawsuit goes until February 28th. As you can see, there's a link scrolling at the bottom about that lawsuit. As of now, we have 48 selectees and their families, like 48 selectees, and we're not counting spouses and children in that number, have already registered. And it looks like the number one country is still Russia. Iran's coming in second, Turkey third, Egypt fourth, Taiwan. Yeah, I forgot that Taiwan has selectees. I haven't had one in that's right. We represented some in 2021. Ukraine, Albania. Oh, I'm not going to say that. I'm going to say it wrong. Somebody want to say that?
Kyrgyzstan?
Thank you. Morocco, Saudi Arabia, Holland, Belarus, Chile. So Democratic Republic of Congo, Ethiopia, France, Germany, Ghana, Italy, Kazakhstan, Serbia, Spain, Tunisia, United Kingdom, and Uzbekistan. So that's where the participants are now. Okay. We can do a lot better. We need more people to onboard under that case, and we need them to onboard now, not at the end of the month, because we've got capacity to be working on declarations now. We will not when it's time to file the complaint. We can't do all the work in one night. So we are grateful to people that sign up, register to participate early. Okay. Okay, you wanted to talk about 75 country pause?
Just an update that we are currently onboarding. Onboarding is closed for all the inquiries we are still receiving. So onboarding closed Friday night or Saturday morning, and we are currently preparing everything for the filing and are not accepting late onboardings. I'm sorry. So all of you who are still asking, that would just not be fair towards the folks that did sign up on time. And we have 258 individuals, 114, let me check really quick, I believe 114 families.
Wow.
And if we count dual citizenships, they are from 28 countries.
Wow.
28 countries are represented with a few dual citizenships.
Out of 75.
So yeah.
That's pretty good representation. So the question that Rabia just prompted here is, are you filing a second 75 country lawsuit? And the answer is, we do not plan to do that at the moment. We are focused on our existing commitments. If in the future we do offer a subsequent lawsuit, we will announce that on our channels. Okay.
That's right.
Anything you wanted to speak to those plaintiffs? Because probably a lot of them are watching, and I don't know.
If they are, thank you guys for being so responsive. The whole preparation is really going great at large. I believe so far we are very, very good on within our timeline that we've set within the team. A few stragglers, if the stragglers are watching, if you are given a deadline to finalize something and you start editing on that deadline, then that's a little bit late. But no, overall, it's growing great, and pretty confident we can make at least the deadline for the attorney side. Curtis, or I don't know who of you guys knows where we are with that, with the complaint prep, but all the exhibits are in really good shape.
I'm hopeful that this thing will come together this weekend. We're going. Hamdi Masri, our associate, has been preparing that complaint, and we're going to get all the attorneys' eyes on it in the next couple of days. And also, we're going to send a draft to the plaintiffs to review before we file it.
Awesome, thank you.
Then, okay.
Nothing else. We can move to questions.
Yeah, let's do that.
All right. The first question is, one of the claims by USCIS against the 39 countries as poor civil docs. Does this make any sense? Didn't people in the past on drastic asylum cases get approved without any civil docs if they couldn't go back home?
To the extent it does make sense, I'm not going to make that argument. Trump administration is not paying me to defend their policies. I think it's stupid. You know what I'm saying? I mean, like, are there legal arguments why it is not stupid? Yeah, but nobody's paying me to make them. I don't know. How do you answer a question like that? Like, that could have been a government.
Yeah, no, I get it.
Question. Yes, government attorney. Why don't you do your homework like I had to? It is true that there are some countries that have less. What do you call that with the civil docs? Less credibility.
Right, and a lot of these documents that USCIS is requesting, these countries historically didn't have them, and they are being created because of this request that USCIS is asking for. So a lot of these things like civil certificates of marriage and of even birth certificates, like they differ from country to country depending on their cultures. And a lot of these documents are very new for these countries. Yeah. So it kind of, USCIS is the one creating this problem.
Yep.
For themselves.
Yep.
Yeah. That's a very good point. There are countries where you request documents specifically for US immigration. Like that's something you check on the application paper.
And like in every country that exists, those in and out of these travel ban countries, fraud exists. Document fraud exists. That's going to exist pervasively in every culture. So to nitpick these countries specifically is, I don't know, hypocritical.
Yeah, it is. Because there's things that we don't have that they have, right? So,
yeah, very true. Amir is asking about an update on lawsuits for 39 countries pause. We went over that, and if I see it correct, we went over that after Amir posted. So that was answered. There are several group lawsuits against the USCIS pause, but none of them appears to be class certified. Does this mean non-plaintiffs cannot expect any relief at all from the courts?
I have heard from the group of folks that work for nonprofits, and they are really close to putting together a complaint. But, you know, they don't always, class actions don't always move fast. So I don't know. I don't know how to give a time expectation on what other people are going to do. But it's somewhere in the future, you're going to see a class certified.
Thank you.
I don't know when that's going to be.
Focus on. Hi, I'm from Haiti. Do you update regarding your lawsuit filed on October 25th for family preference categories? And is it possible to have a new lawsuit for this category? I've missed my chance to participate. That's a family preference presidential proclamation 10949.
Right. I think Mirage is the name of it, right? 530. Our internal number is 539. There was a development in that case recently. Let me see what it was. Yeah, we thought we'd be talking about that travel ban a lot more, but that was before all these other barriers popped up.
Yeah. There's
a status conference on February 19th in that lawsuit.
It's next Thursday.
Yeah. And that's with Judge Ogwin, Central District, California. I didn't realize we had so much diversity on that lawsuit. We have plaintiffs from Iran, Yemen, Afghanistan, Somalia, and Cuba.
Yeah.
So the lawsuit is moving. The government filed a motion to dismiss. We filed an opposition, and they filed a reply on January 15th. So the lawsuit is moving. So that's the only updates I have.
Okay. So maybe in 2 weeks we have another update.
Yeah.
Wonderful. The next question, if a class action lawsuit is filed, like you said, would this cover the USCIS 39 country pause? Also, when can one expect a PI? Curtis, continue answering for other attorneys, please.
What? Okay. Like you said, would this cover USCIS pause? I can't talk for another attorney on what their lawsuit's going to cover. But yeah, that's what my answer to my question was. There is a group of nonprofits that are considering a lawsuit against the USCIS holds. Don't know why you're calling it a pause. USCIS uses the word hold. State Department uses the word pause. Okay. But whether or not they'll do a PI, I don't know if they'll do a PI or not. Even if they do a PI is not a guarantee that the PI will be granted. For a PI to work, you need to show irreparable harm. You need to show balance of equities tip in favor of an injunction. You need to show likelihood of success on the merits. I'm forgetting a winner factor. Which one?
I think you got them. Balance of equities.
There's two that make it together.
Yeah.
So
private interest.
Public interest.
Public interest. Yeah.
Yeah, merges with the balance. Right.
Mm-hmm. Mm-hmm.
So anyway, what was I getting at here? Even if there is a PI, don't assume that the PI is going to be granted.
Yeah, the hurdle is high in the PI standards.
Yeah.
Also the class certification as well.
Yeah, the hurdle for class certification isn't so high so much as the government fights them like crazy.
Mm-hmm.
Like this thing where we're filing lawsuits every day in courts all over the country, and they're getting sued thousands of times. This is a choice. The government has decided that they don't like class actions, and they prefer to be sued over and over. Like people that, what's that word, masochist or something? People that like to be abused. I mean, like they like a lot of lawsuits, I guess. I don't know. It's really strange.
Did you see the news?
For themselves.
No. You guys are about to go down a dark hole again.
But
news, yeah.
But did you see the news from Minnesota that the U.S. attorney who broke down during the hearing, and the transcript is
she no longer works for the government. So in yesterday's hearing, one of the arguments the government made for what's called track factor 4, on whether or not the delay is unreasonable or not, is that our plaintiffs were trying to skip in line in front of the other victims of the policy. Okay. Why is that related to what I'm talking about? I don't even know how it's related. But yeah. So I said, well, Judge, isn't this what the Supreme Court wanted? Because if we wanted to go for, I would be happy, Judge, if you gave relief for everybody. But the Supreme Court says you can't do that under Trump versus CASA. So the government's argument here is they're upset with the Supreme Court. That's not me doing this. So Anyway, and then about part B of that argument is this isn't a line of victims waiting for USCIS decisions. If you're in a waiting room and everybody's got a number, but nobody's coming out the door and calling numbers, that's not a line.
Yeah.
That's a room
That's
full
torture.
of staff.
That's almost like just torture. You're just keeping people waiting. That is, in my definition, that would be one layer of hell.
Yeah.
It's like playing bingo, but the person that's calling the numbers is dead. Anyway.
There's a movie there somewhere.
Okay. But yeah, we don't know on the PI. To close out that question. Hi all, I've joined the 75 country pause and wondering if judge grants a TRO. Is it highly likely another lawsuit also gets one, assuming they make the same arguments but different judges? We're not filing a TRO, we're filing a motion for preliminary injunction. So let's answer this with regards to the preliminary injunction instead of the TRO.
Right. I think the reason they mentioned TRO is there was a case in Arizona, or was it Nevada? The adoption case. The adoption case had a TRO.
Yeah,
extremely unique situation, though. We will not be filing TRO. The bar to get a TRO is very high, and also the result of getting a TRO is not that great. Then you have to go back and get the PI to make the TRO permanent. It's just, yeah, agree with Rabia. Let me see here. So, is it likely that another judge will do the same thing that the first judge does? It's possible, and they're going to definitely look at what the first judge does, but they have independence from each other. All the judges are equal. You know, one judge's order is not binding on another judge unless the judge is a circuit court. The case is at a different level. So it's possible, but not guaranteed.
Thank you. Barry is asking, what are your takeaways from the Sangster and the Clinic lawsuits? And is there anything that you might use in your 75 country lawsuit?
Sangster's the adoption case, right?
That's the adoption case, yeah. And Clinic is the New York.
Okay, my takeaway on the Sangster case is the judge did the right thing, but the way that she got there was wrong. She thought that she had to give relief because once the applicant, in that case it was a adoptee, got a 221G notice, she thought that she'd be stripped of jurisdiction, that she couldn't do anything. A minority of judges take that view. Most of them are in Florida or Texas. And it's not a view that I stay away from judges that have that view. And I don't usually point to their opinions when they have that view because I think that's nonsense and I don't want people reading it. I don't want other judges looking at that and getting ideas. So
it's been characterized by other judges as illogical. It's an illogical
that's true
assessment. So
I'm just thinking the chief judge of the Eastern District of California, right? I don't think she used the word. I think she used the word.
Leads to an absurd result.
Well, that's an absurd result. Yeah. So, okay, so let's go to the next one. Clinic. This is the lawsuit by the C in Clinic. The first C stands for Catholic, and it's filed in the Southern District of New York. And there is so much misinformation about this lawsuit on the internet. It like wastes an hour of my day trying to set it straight with people. There's no TRO that's been filed. There's no motion for preliminary injunctions. The summons has been issued, and the attorneys for the plaintiffs are entering their appearances and getting their motions for pro hoc vice granted. But there's no PI motion, no TRO. I don't know why that, and there's no hearing scheduled. There's no order coming this week. I don't know where that information is coming from, but it's all false. We have reviewed that complaint. There's lots of good things in it, and we are borrowing some things, not everything. One very distinct approach that we are making different is that lawsuit actually points to some of the public charge vulnerabilities of the plaintiffs. Like this plaintiff was on food stamps once because, their family was struggling. Or one time this plaintiff was sick and couldn't pay their bills. I don't think we don't want to use that approach. I understand why they're doing it. It's not what we're doing. And I think one of the reasons they're doing it is they're saying this whole thing is unlawful for everybody and let's get a universal injunction.
Mm-hmm.
So glad I got to weigh in on this. The clinic lawsuit is trying to expand or preserve the rights of federal judges, the authority of federal judges to issue universal injunctions. That's one of the things they're betting on. It's possible that they could succeed in that, but not a guarantee. So yeah, there's stuff we're going to use for both of those lawsuits, but we're definitely not copy pasting everything.
Thank you.
Oh,
this is nice. Joined the lawsuit from York. Glad you guys have this transparency and communicate thoroughly with us. Thank you. That's good to hear. Barry, how's the prep going for the 75-country lawsuit? Are we close to finalizing a complaint? That was from 20 minutes ago, so we answered that. Thank you. But feel free to follow up in the plaintiff Telegram group, the plaintiff only group. That's where we want to communicate those things. If you didn't join on time. Can immigration policies be challenged and argued by the government that it is indifferent from the actual immigration law in place?
Does anybody understand that question?
I feel like that they are doing that every day. they just argue their political slogan, not with
no. I think I know what the question is. There's lots of chatter at the moment that all these policies, like all these pauses and halts right now, bring up things that actually are supported by the INA, but were just never enforced. Okay. But that there's technically they can be as harsh and make all these new requirements. It's just that nobody ever looked at it from such an evil eye to interpret the law. I think that's what the question is.
That's a great question. And I think a lot of it came out in our hearing yesterday on the subject of 8 USC 1252, which is a section of the Immigration and Nationality Act that gives the Secretary of Department of Homeland Security, actually originally the Attorney General, it's weird, the authority to set up processes on how people's adjustments happen. Well, it doesn't give the authority on how to make them not happen. Like, you know what I'm saying? It's like, it gives him the authority to set up like processes. Yes, not roadblocks, not ways to stop the thing. So I don't think the judge found that compelling. Courts in the Ninth Circuit have definitely not found that compelling. So the government, but there's a key part to this question that I do want to answer, and that is, and argued by the government. If there is a crazy, absurd argument that's wrong, yes, the government's going to make it. They have to grasp at every straw. So,
also, for the 485s, I think since those people are in the U.S., they are the person like protected by the Fifth Amendment, and protected by due process, procedural due process. So
that's one of the great things about the USCIS group lawsuits for people that are inside the U.S. We actually do have a constitutional cause of action. In the first lawsuit that we filed, the government didn't oppose the likelihood of merits on that. Instead, they're going after jurisdiction and saying that there's a jurisdiction stripping statute, which is crazy because jurisdiction stripping statutes, what I'm talking about is 8 USC 52. It doesn't matter what it says if there's unconstitutional conduct. The Constitution stands over here by itself, and here's all the statutes and regulations. And no matter what the statutes and regulations say, the government cannot be acting unconstitutionally. So I'm very confident that we are going to have success in the lawsuits challenging the USCIS hold.
Thank you. Hind is asking for 75 country pause. Is the signature for the declaration required only from the petitioner? Yes. Does the beneficiary have to sign anywhere? No. Lastly, I'm sorry, I have some unexpected events early in the week, so still going back and forth. Yes, we are. Yes, but let's also look to wrap up today or tomorrow, because as the attorney said earlier, we're actually getting very close to filing the complaint ahead of deadline, and we don't want to be the holdups that the PI motion can follow quickly after that.
Also for our clients, don't so what you are doing now, you're piercing your own client's attorney privilege. So don't do that anymore. Just contact us privately.
So glad you said that.
Yeah, so the purposes of
that's what we have the Telegram group and emails.
I'm going to change the name of Let's Talk Immigration to Let's Talk to Non-Clients, because that's what this show is for, people that have not hired us. If you hired us, well, you've got access to your paralegal, you've got my phone number and email address, and we can talk about this amongst ourselves. We don't need the government attorney to follow our conversations. But take Lynn's question off, because it sounds like I'm bullying her, and I'm not. Other people do this too. Thank you.
Is it easy to override the first pause, the national security? Is it illegal like the 75 country pause? The first, are you referring to the travel ban?
The first pause was early November for Afghans, and I don't think you're referring to that.
No.
You're referring to
probably the travel ban.
1049.
Maybe the USCIS pause. Okay.
Clarify which pause. Oh no, because it's an obstacle for DV winners as well. So it's there's a second.
So which
DV or travel ban depends on the country.
You mean DV winners outside the U.S.? Because believe it or not, DV winners inside the U.S. could have two other different challenges. So is an obstacle for DV winners. Okay, so yes, there are DV winners who face the DV pause and the 75 country pause, and our DV group lawsuit that onboarding ends February 28th challenges both of those obstacles. Which one is easier to defeat? Good question. Had not thought about it a lot. Both of them are based upon lies. The 75 country pause is vulnerable because statistics do not support the basis that immigrants are at a higher risk of being public charge. They just don't. David Beer has done a lot with the Cato Institute, has done a lot of research and published it on that recently. I'm trying to remember what was the basis of the DV pause. Some guy from Portugal came out of the U.S. and committed a crime. And the only way I think
he came in 2017, right?
Right, is like Stephen Miller has a Google News alert for DVs. And what's weird is I have a Google News alert for DV, but it's because I just watched the program. He has it because he's waiting for of the millions of diversity visa selectees who have entered the U.S., and I think it's a few million since 1990. He's waiting for one of them to commit a crime so he could say, aha, He doesn't have a Google News alert for like white bald guys in their 40s. Because if he did, he'd be very busy. For those who don't get the joke, that's what Stephen Miller is. So anyway, I went off. I'm too far from the question to even get back to it.
Okay, so if For DVs, are you challenging both, and is the DV pause as easy to challenge or feels as easy to challenge as the 75 country pause? That's the question.
I don't know. Or are DVs from Portugal in 2017 that big of a threat to our national security? Okay, here's why I think the 75 country pause is the more one that's easier to defeat. In 2020, the same president, Trump, issued a presidential proclamation saying that we have to stop immigrants, not because they're lazy or public charge, because they're stealing our jobs. So here you've got a president who says all these immigrants are stealing our jobs. Now they're saying that they're so lazy, they're living off the government.
That's been the paradox of the immigrant.
Also in Texas, they argue that immigrants steal all the housing, so that housing here are so expensive.
You know what makes me mad about that argument? What makes me like super mad is I used to be in real estate and I was around new construction a lot, and we would not have the abundance of suburbs in the United States if we did not have underpaid immigrant labor. That's who built the suburbs of America. And then these assholes want to come and say they can't live in these houses. I just have no tolerance for that.
Okay.
I'm going to get us thrown off of YouTube.
Next question is if you're willing to file a group lawsuit for opt and stem opt, because they have a short timeline.
We're onboarding it. Opt and stem opt is the I-765, right?
Yeah.
I'm not crazy, right? Okay.
Yeah.
So let's do show and tell for a second. I just clicked on invite people to the studio. We should do that sometime. Okay. Group lawsuits, all group lawsuits. Pending I-765 applications right there. And from the time you onboard, if you've already participated in another lawsuit, you get to register as an existing client. If this is the first lawsuit you're doing with us, you're a new client. From the time you register, you're going to be on a lawsuit within 30 days of onboarding.
Thank you.
Okay.
Next question. Would you say the lawsuits challenging the USCIS pause are stronger than the CHNV or FRP cases because they violate INA and are not based on discretionary prerogative granted to the executive branch?
I don't answer questions with 4 acronyms. A rule. Anyway.
Zainab, plaintiff questions, please ask in the plaintiff group.
No. Well, okay, so no, we could.
Oh, you are trying? Okay.
Just joking a little bit. Remind me of CHNV. That's humanitarian parole for somebody, right?
Yeah, right. I just Googled.
Bad with acronyms. I think it's different. The statutory scheme is very different for humanitarian parole than adjustment of status, other immigration benefits. It's FRP.
Family reunification parole.
Oh, so it's parole. Yes, just parole is different. It's a whole different basket. We don't litigate in that space because it's different, and I'm careful about doing something different. I want to learn everything about it first.
Okay, thank you. For DV 2026, the hardship and danger information we provide on the website, on the onboarding form, will that be public?
We're not going to make your onboarding form public, but we will draw from that to, for some plaintiffs, the ones that registered earlier, we will draw from that to prepare a declaration to send to you to sign. First, you have to review it, make sure everything's right. Okay, you don't want to sign something that's not right. And then if you do that, then we would make that an exhibit to the motion for preliminary injunction. Now, our dockets, we file them under 465. What that means is they're not going to be publicly downloadable by anybody but us or the government attorneys or the judge. That's it. That's the circle of who can publicly download it. But if somebody's ambitious and they want to get in their car and go down the courthouse and go through security and go up to the 4th floor or whatever, they could see the exhibit and they could actually even buy a copy of it. So if you got some great big secret that you cannot let anybody in the world know, don't put it in the declaration. You have to weigh this. Sometimes people have a secret, but it's helpful to the lawsuit. Maybe it's worth it to take this risk. Because we definitely need some facts in the declarations of things that are going to go wrong. Because if we don't have that, we don't have the tools we need to get the motion for preliminary injunction.
Yeah. Thank you. I'm affected by the 39 country hold and I intend to apply for AOS in 2 to 3 weeks. Do you guys plan on having revolving lawsuits as more and more people get eligible to apply for immigration benefits? It's exactly what we're doing.
That's what we're doing. That's it. That's our status quo. We're following about every 30 days.
Also, on that, I want to add that maybe we are also considering challenging the 2 USCIS policy memos for the I-140, I-130, I-526E petitions, because we think they are also affected by those USCIS holds. So
right.
Probably
are we adding I-129s as well? I mean, that's the only petition we're leaving out right now. I-129, I-129F.
Curtis and I talk about it.
Okay, so there's I-129s, I-129Fs. The I-129s are for H-1Bs, and that path has other obstacles, and I just don't even know if it's realistic. So I don't think 129s we're going to include. 129F fiancés, I haven't thought about it, so we'll announce in March that lawsuit, but it will be more than one, just more than I-130. It'll be I-130, 140, probably what Chuck said, 526. I don't know about 129F. Maybe. I need to think about it.
Okay. Imran says, preach, Curtis, preach.
I said a lot of crazy things. I don't know which one you like. But, okay.
What are the odds of winning after Senator Kennedy was shocked after he heard the situation that Beer told for the DV 2026 pause?
You need to go into YouTube and type Senator Kennedy shocked. Basically, he's a character. He's one of those guys. He's like your crazy racist uncle or something that you're like, I hate the way he votes, but he's actually fun to listen to. I don't know. He likes to have fun, but you don't want to see his voting record. Anyway, so I don't think I got across the fact that 1 out of the 100 senators has very little influence over what's actually happening in the country.
Okay. Mandana is asking, is there a hope that they process the cases for people inside the US, like a change of status to H-1B?
I'd love to know what countries they're talking about. I think they're talking about people from the 39 country.
That's what I was going to go say.
Inside US, yeah.
Yeah, if you're from the 39.
So the USCIS policy memos, they are putting those 39 countries on hold, right? So in the US, you are not affected by the Trump's H-1B presidential proclamation. So that's probably the only obstacle. And well, in my opinion, I think we should add this to our group case to later this month for
Well, here's the
to
deal about
challenge
it.
it.
All the H-1Bs from the travel ban countries, when they file them now, they're getting notice of intent to denies or request for evidence
Oh yeah.
look like this that talk about your country being like bad, like you're from bad country. We don't know what to do unless you're coming to the Olympics, and then it's okay. No, if you're an athlete or a family member of an athlete, then it's okay. Minor child of a U.S. citizen, not okay. But spouse of an athlete for the Olympics, it's okay. Crazy. Anyway, what these noids say is that you have to give them evidence of your good standing, participation in your school or community, affidavit attesting to your good character to make up for the fact that you're from this country. Nobody's been refused following this because there's a freeze on adjudications. The reason I'm scared to file a lawsuit on behalf of pending H-1B 129s or 539s is they just decide to refuse them. And then we have another lawsuit that we have to do challenging a different lawsuit, okay? Challenging the policy memo, the ability of the USCIS to take into account the country that you're from as a factor. And I think that's going to be a more difficult lawsuit. Does that make sense?
Yeah.
Yeah. Also, on top of that, so there are Chinese visitors or workers who want to change status to F1, and they are under the PP 10043, and lots of them when they want to change to students F1 status, lots of them already got denials. So probably a similar situation, but it feels they are just using this.
Still in effect. 10043 is still in effect.
Yeah, it never got revoked.
Now, why would Biden not revoke that? I don't know. For you all that don't know what that is, this was a Trump proclamation from May of 2020. That just that's so weird that it suspended entry of non-immigrants of certain students and researchers. That's still around. So many barriers.
Yeah. So I guess it's a no, but a maybe, or is it a no?
It's I don't know what country you're from.
Okay. But glad we went on a tangent for 5 minutes.
I could ramble.
If you win the lawsuit challenging the presidential proclamation, so that's our cases 539 and 571, right? And 515. Do you think this decision will be only favorable for visa issuance or also for entry?
So you were doing our internal case numbers, right?
Yeah.
Because I was looking at the CM 178, CM 328, and then also the one in Central District, California, and Massachusetts. There's like 6 of those lawsuits. So how do you say we win the lawsuit without telling us what we win on? We have challenges to both of the things that you talk about. So the judge could agree with us on one and not the other, or the judge could disagree on both. What Judge Suknanan did in Fine versus Trump has agreed with us on the 212F issue, but not that the travel ban was unlawful. So multiple outcomes to a lawsuit. Judges don't come out and do this. They use words, and the words have meaning.
Thank you. Munta is not a plaintiff on the 39-country pause lawsuit against USCIS, knowing that Trump v. Casa decision by SCOTUS prohibits a universal relief by federal judges. Can a universal relief still happen?
There are people that are trying to do that. It's not us, but the clinic lawsuit, the Catholic lawsuit, appears to be doing it, but not for the country pause lawsuit. They're doing it for the 75 country pause lawsuit. Also, there's no 39 country pause. It's 39 country hold. It's USCIS, it's a hold. It's State Department, it's a pause.
But you said for the hold, there possibly is a class action on the horizon in the future. We just don't know when. And if a class gets certified, then maybe.
Right.
Okay.
Yeah.
Does it make sense for someone who just applied for AOS to join a lawsuit, being that adjudication takes several months anyways, and the hold only affects final decision?
Well, litigation isn't done in a couple days. So wouldn't you want to remove the barriers? So what? I mean, it depends on how much time you're going to be alive here. And if you value all your time that you're alive, because if you do things subsequently, like, oh, I'm not going to do this until that happens, and I'm not going to do this until that happens. I mean, you're going to end up being 60 years old. Like, oh, I got a visa. Let me get a flight. You might already be 60. I don't mean to, I'm almost 60. I didn't mean it that way. Anyway.
And this is under the presumption that this individual is being subjected to a policy, right?
I think they said that earlier.
I don't, I wasn't aware it was the same.
Here, if a class action, would this cover the country pause? I think based on that, the same. I'm affected by the 39.
So after the I-485 is filed, you can file a lawsuit, and then ideally, once your adjudication time comes around, the pause is no longer impacting.
Yeah, it's gonna be rambling. I should just yes.
I try to summarize at the end. Next, Mandana was asking about, that was the change of status is from Iran. If that changes anything.
Well,
you want me to go back to the question?
I see it, but yeah. So if you're from Iran and you file a change of status, you're definitely going to get that notice of intent to deny that says, hey, can you prove to us that your other good moral character makes up for the fact that you're from Iran? And so now's a good time for you to start volunteering on the weekend, something, picking up trash or a soup kitchen, or I don't know.
I don't even know that is an authentic standard that they've set that is even attainable. I wouldn't take it on their word that they're going to listen to an individual's attestment to like their good moral character. I don't know why USCIS would legitimately and in good faith take that into account. So
I like to think that officers try to do good faith. The bad faith happens at the top, at the policy level. USCIS officers, I need to send you to some more interviews, Catalina. They're usually good people. They usually roll their eyes when they're doing things that they know that are wrong. So.
Yeah, and I guess my indictment is on the top. Yes, it would not be on the officials just trying to do their jobs.
So, yeah, I'm not in a hurry to do a 539 decision because most people with a pending 539 are not in a hurry to find out what's going to happen with that.
Okay. Abbas is asking, what about F4 visa? My file is from 2010. Can you talk with the judge in March? Without Corona and new rules, maybe my family in America from 2024, 2025. Oh, the visa bulletin, F4, I don't think for a single country is current. 2010, that's years away. Can you ask the judge to move the visa bulletin, Curtis? That is the question.
No judge is going to move a visa bulletin ever. But Now that I said that, the DVs are all saying, "Oh no, what if the visa bulletin freezes forever?" That's not going to happen. Okay, but I don't think they said what country they're from when you're talking about the visa bulletin. What country you're from, because they separate it into a few different countries here. So, assuming that you're the rest of the world countries, you still got a couple years to wait.
Yeah.
Okay.
Cool. Next question. How long after the PI hearing do judges usually rule? I like that question. We hear that so often.
It varies. Usually, if you're going to get relief, the judge is going to give it within 30, 45 days. If a judge sets on a PI motion for longer than that, it's kind of a hint that the judge is not planning on giving you PI relief. We had a judge do that in New York in our case called Sunny. There was a sister case, Chuck. What was the name of the sister case? Anyway, the judge did not give us an order on the PI motion for a while. And after a while, I started thinking, this is not a good sign. And then eventually he refused. He denied the motion and dismissed the lawsuit at the same time. So if you don't get relief within 30, 45 days, it's not a good sign.
Thank you. My OPT expires in August. If I win H-1B lottery, will there be enough time for me to join a lawsuit? I'm from Iran.
Yeah, I think we just went over this, that we are, so Curtis just said we're not planning to, probably not going to file a litigation for the H-1B. But specific to your question, if you win the H-1B lottery, that's going to happen in end of March this year, and then you have to file your employer has to file the H-1B for you before the end of June, and that will give you gap to extend your F1 all the way to October 30th. September 30th. So that you can, in normal time, that will connect directly with your H-1B on October 1st. But given what is happening with USCIS policy memos, we don't know. And but you should get if you are selected, get the H-1B filed as soon as possible. Another news on H-1B is that this year they are changing the rule of lottery. They are not doing a random selection, but selection based on wage level. So it's very important to talk with your employer on on how your H-1B position is going to be.
Or you could book a consult with Chuck directly from our website too, because this is a very
good point.
Question about your specific facts.
Very good. I would suggest we're already past the hour. We'll do 2 more questions and then we wrap it up.
Sounds good. 2 more.
Awesome. A bit off topic, but my mom filed an F4 case in April 2009. Country is Pakistan, or no I-130 approval yet. I know it's still not current on the bulletin, but is that long for I-130 approval normal? I've seen it.
I've seen it too, and I've got a consult with somebody tomorrow to talk about it. Here's the thing. It's not a bad situation. There's no benefit to having the I-130 approved yet, except the peace of mind of knowing that it's going to be approved. And there is a slight disadvantage for many families because it impacts what's called CISPA, age determinations for older children. So people racing to get their F4 decisions need to realize that they're racing to leave their kids in India or Pakistan. That's not always what you really want to do. Your kids will get mad at you about that. So
yeah. And I think that's so important for families to understand that as long as the I-130 is pending, it was filed with USCIS, accepted by USCIS, and not approved, the age of your children is frozen. Once the I-130 is approved, your child starts aging again. So if there are any children on the cases, an early I-130 approval is not what you want. Look at once you're current on the final action chart of the visa bulletin, then ask for your I-130 approval if you don't have it by then. That's really the safest way to get children to immigrate.
I mean, if you've got some really bad kids and you want an I-130 approval so you could leave them behind, get with me and do a lawsuit.
Last question. I'm a citizen of Finland, but born in Iran. Filed my I-485 in the US, EB2. Now an interview is scheduled for me. Is there any hope that they remove the hold before September because my J1 will expire by then?
There's a lot here. Dual national.
That's all I was focused on. I was like, I'm a citizen of Finland.
Actually, maybe not dual national. You don't say you're dual national, and I don't think in Iran, right, you've got your father has to be a Iranian citizen.
But USCIS doesn't have an exception. They go by country of birth, right?
Yeah. No.
Let's just assume dual national. Finland, Iran, filed I-140, EB2. Now an interview is scheduled for me. Is there any hope that they remove the hold before September? Okay, so there's hope if you sue them. I mean, if you sue them and a judge compels them to remove the hold. So I don't know if you're participating in one of our group lawsuits for 485. Right now we filed 2 of them, and we are onboarding a third. Isn't that right? We filed 1 in Maryland and 1 in Colorado. Yeah. Where are we going to file the next one? I don't know. We'll see where the plaintiffs are from. But awesome. Yeah, so participate in a lawsuit.
Yeah.
Okay, that was the second question.
There was a second, just really quick before we wrap up. Abbas, that was the F4 with the 2010 priority date, is saying he's from Lebanon. So that is the everyone, the all countries, and yeah, they were 10 months without any move on F4, so that's his concern. But Abbas, there's nothing the courts will do about it.
Right. And here's why. I've tried to get the courts to do something about the visa bulletin indirectly, because here's what the problem is. USCIS is not exhausting the annual allotment of family preference category visas. So they don't move the bulletin. Like the line just keeps getting longer because they're not even using the visas they have available. I say USCIS. Why did I say that? I should have said the State Department. State Department has 226,000. Yeah, 226,000 visas a year, and they never use them all. This year, I think that there's the record number of employment visas because of how few they used last year. They roll over to employment, and some people want that to happen. So that's probably why there aren't lobbyists for families pushing to fix that.
Right.
But they never. But the last time that happened, they didn't use all of them, and they got like 20. So they got like 50,000 of them, but only used 2 or 3. I mean 30 or 50,000, but they only used 20 or 30,000. Not all of them.
It's a fraud. It's a fraud scheme. They roll over from category to category just to not use them in that next category as well. Okay, but I think that wraps it up.
I was like, you're going to open a rabbit.
Curtis, a few closing words.
Yeah. So, does anybody know if Hacking's hearing on Friday is Zoom or audio? We'll be watching that.
This isn't the case assigned to Amy Bernie, Judge Amy Bernie Jackson, right?
No, no.
Maybe ask him.
I don't know. It's on the website. I just haven't been to it yet. Anyway, we'll be watching. That's the thing to watch on Friday. And then on the 19th, which is the day after our next show, you'll want to tune in to hear Garrett before the circuit court arguing about the travel ban. So that's what's coming up.
Awesome. Thank you.
Thank you for joining me, you all. I appreciate it.
Thank you.
It's all.
Thanks.
Have a good week. Bye.